you see, just you cannot walk in.
Yes.
Any chief minister of any state,
Yes.
just walk in the midst of an inquiry or investigation, and you see, make the democracy in peril. Who happens to be the chief minister, keeping the whole system and whole democracy in jeopardy.
Well, respectfully, I'll disagree with that.
This country, a day will come when a sitting chief minister will walk in to the office of some other investigating agency.
Yes, when we come to facts, we will assure and we will convince. I am still on my next. If I may please finish. I am still on my next. My lord, this is only Mr. The central government had appointed a commission of inquiry there against the chief minister of Karnataka. Now, may I take you straight away, my lords?
So, what right of the state is involved in this?
No, my lords. It is that if there is a dispute, that's why I'll just read.
No, what is that dispute in this case between the state and the union?
No, my lords. If there is a dispute, and here the dispute may well be, this is the extent.
No. We are sorry.
Yes.
This is not a dispute between the state and the center.
My lords, here. The union?
You cannot, you cannot walk in.
Yes.
Any chief minister of any state,
yes,
just walk in the midst of an inquiry or investigation, and make the democracy in peril, and then argue that it's a dispute essentially between the state and these are individuals.
Incriminating evidence is taken away.
Yes.
Incriminating evidence is taken away.
What is this kind of, don't convert into a dispute between the state and the union. This is not per se. This is per se an act committed by an individual who happens to be the chief minister, keeping the whole system and whole democracy in jeopardy.
Well, respectfully, I'll disagree with that. And I'll show you why. Please allow me to just develop my argument and I'll show you why.
Yes.
Yeah, please allow me that, my lords. I'll just develop the argument. I'll also place for the possible question and dispute under 131. So I will start, my lords, by just reading what does 131 speak to. Your lordships has this, my lords, paragraph 146.
Which central government or ED officer can seek an inquiry by CBI in a suit under 131? Tell us.
My lords,
that relief can be granted.
My lords, we are not
by the Supreme Court.
No.
Directing a CBI inquiry in 131 suit.
No, my lords, but here they are not asking. They are saying that their officers' fundamental rights are being violated. That is their case.
No, that is their case.
That is their case. They have come to you on this.
You are saying that if at all this can be maintainable.
Yes.
This cannot be maintainable under 32, but it can only be under 131.
No, my lords, I'm not
that
saying
is what you're
that
arguing.
That we have a legal question, perhaps, that has not been countenanced before, that has not been formulated before, that there may be a legal issue between what should be the union, not the enforcement directorate, not two individuals who are officers of the enforcement directorate under 32. That is my only point. They have not come under 131. They have not even come as the Union of India.
No, but it's your suggestion.
No, I am saying if your lordships were looking for a plausible way, then that plausible way would certainly not be a writ petition, a 32 petition. There may be a dispute between the union when the necessary party and the proper party would be the Union of India and the proper party would be the state. That's all I'm saying. My lords.
Therefore, we are asking
yes,
whether in 131 suit, a relief of this nature, seeking direction for a CBI inquiry, can be sought in 131 suit.
My lords, but they are not seeking that.
They are seeking
the fundamental rights of the officer being violated. They are saying the fundamental right of the officer is being violated, and therefore they want a CBI. There is a difference there, my lords. They are not coming as a suit. They are saying this is a fundamental right violation of these officers who are officers of the Enforcement Directorate, which is a department of the state of the Union of India. You can trace it from the Ministry of Home upwards. That is all I'm saying.
146 of
yes of this case. Yes.
You see, you have taken us through Sirvai, through Ambedkar,
Yes,
through
Manoj.
Keswanand Bharti,
Numerous other cases also.
but none of them
Yes.
would have ever conceived of this situation that in this country a day will come when a sitting chief minister will walk in
With
to the,
respect, my lords,
to the office of
my
some
lords,
other
that is
investigating
not the
agency.
case. When we come to facts, we will assure and we will
Honorable Chief
convince.
Minister has
I am
signed
still
an
on my
affidavit.
legs. If I may please finish.
Only a minute.
I am still on my
Honorable
legs.
Chief Minister
My
has
lords,
signed an
this
affidavit admitting.
is only Mr. Mehta grandstanding for whoever he thinks is not in.
You see,
This.
we are
This.
saying that it is proved as of now. But
Yes.
the
When
facts
we
on
come
which
to the
the
facts, my lords,
the
I am
facts on which both the petitions
I'm on
are based.
maintainability, my lords. With respect, I'm on maintainability, my lords. When and if and when we come to the facts, then certainly we will convince your lordships. We will do our best to convince your lordships. And as for grandstanding, my lords, it has no place in a courtroom. There's no place in a courtroom. Now, my lords, may I just read para 146?
Yes.
Sometimes even responding is degrading your own dignity. So, respectful silence is my response.
My lords, I don't know what these similes and homilies the SG speaks in, my lords, but I'm sure he's convinced himself. So, my lords, this pertained to a commission of inquiry, and this was framed then as a dispute between the union and that state. Therefore, I'm citing this, and I will come back to this. Now, if your lordship is then considering possibilities where there is a legal dispute, a bona fide legal dispute, then all I am suggesting is the Constitution provides pathways. The Constitution certainly doesn't intend for official functionaries of a state agency, which is fairly powerful, to come to your lordship's court and say, my fundamental rights are violated. If questions relating to the character of Article 32 writ jurisdiction, union, state dispute, etc., qualify as substantial questions of law, if any. The union could have done this maybe somewhat more appropriately, my lords, or more legally tenable. But they've chosen the most legally untenable way to advance whatever alleged grievance they have, and we are not here on facts. We are only here on maintainability. We are only here on that. When we come to the facts, your lordship will see there is no situation as described by my friends on the other side. And I'm very cognizant as an officer of the court when I say that. There was no criminal conduct, there was no intimidation, there was no infraction of any official. Questions relating to the character of Article 32 writ jurisdiction, union, state dispute, etc., qualify as substantial questions of law and hence trigger Article 145(3), mandating a reference to a larger constitutional bench.
But before that,
Yes, my lords.
in an appeal,
Yes, my lords.
this is not an appeal.
My lords, but this
We
is
are dealing with both the petitions under 32.
yes, but my lords, then therefore I'll be framing the question with regard to
No. For in every question there will be some question of law.
No, my
That
lords.
doesn't mean
My
that
lords,
every 32 petitions should be
this
sent
is
5 judges.
this is a unique proposition which they are advanced, unknown to Indian constitutional law, my lords.
We do not
Unique.
know who has
Unique proposition.
mooted their
My
proposition.
lords, in 75 years, we have never seen a proposition such as this. Never seen a proposition such as
What
this.
proposition?
The proposition that the enforcement directorate's employees
No, these propositions
have
are
Article 32 right.
now they keep on coming.
No, my lords,
Every state is filing 32.
And when your
every other.
lordships are confronted by the enforcement directorate's conduct, your lordships in contemporary times have only reined in the enforcement directorate in the context of privacy, in the context of search and seizure, and in the context of overreach. That is what your lordships have done in the last 2 years. And when we come to the facts, my lords, if we do that, we will take your lordships to those cases.
We will decide whether 32 is maintainable or not.
Yes, my lords, and that is what we are arguing about.
What is that substantial question of law which requires to be heard by 5 judges bench?
No, my lords, whether
that
in fact,
in a 32 petition itself.
My lords,
read 101 again.
Yes, my lords. Where the court is satisfied that the appeal involves a substantial...
Appeal involved.
The appeal.
We are not dealing with appeal.
Yes.
We
So, my
are
lords,
dealing
what
with
I'm-
two writ petitions.
Yes, what I'm
So
suggesting.
first prerequisite is not satisfied.
Yes, but what is satisfied is that there is a substantial question of
No,
law.
but that should be
which
in an
pertains-
appeal. That should
which
be in an appeal.
pertains a substantial question of law.
We are
which
not hearing an
pertains to an interpretation of the Constitution. Because a petition like this has never been advanced before, it poses a substantial question of law, which your lordships.
Sorry,
have
we
to
are not
consider.
hearing an appeal. We are not hearing an appeal.
But my lords, have your lordships ever considered a question?
Otherwise,
as to whether-
in every petition, there will be some question of law which you will say needs to be referred to larger bench.
My lords, the Sabrimala review, which your lordships are now hearing, is the review going to a larger bench?
Yes, it can.
The review is going to a larger bench because your lordships felt convinced that there is something in the review which poses a large-scale constitutional dilemma.
When either of you come in review before us, we will decide that.
No, but my lords, the point is that when there is a substantial question which involves interpretation of the Constitution, then if your lordships feel it arrives at that height,
Mr. Sibal has joined.
that your lordships must refer it to a larger bench.
His arguments are over. His submissions are over. He must have joined.
Yes, yes.
Just to be enlightened.
Yes, yes.
My lords, so that is the point, that when your lordships are satisfied, just like in Sabrimala, your lordships felt there was a constitutional dilemma that was posed, which the review presented. And then my lords created and put together a 9-judge bench. Similarly, here I'm saying, my lords, whether the enforcement directorate can prefer a writ under 32 poses a constitutional dilemma for this court, where for the last 75 years, we've only understood Article 32 to be in the nature of enforcement of fundamental rights questions. That is the question that my friends are posing. And that, in my respectful submission, warrants then that to be referred to a larger bench if my lords feel that there is something meritorious in their submissions. That's the only point, my lords.